Please rise. Justice of the Appellate Division, Supreme Court, first call. All persons having business with the Appellate Division are here to be defended and you shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have almost 6 hours of argument time requested, so only ask at the time that you need, not the time that you want. We are familiar with the briefs and the records, and if we need additional time, we will keep asking questions. People versus Erica Woods, appellant.
Yes, Your Honor. The appellant request 6 and 1. Respondent request 4.
6, 1, and 4. Zito Group versus Baker, appellant. Respondent.
Thank you, Your Honor. Neil Klausner, Davis and Gilbert, 5 minutes.
5, 1, and 5. Rondo versus Houston. Is the appellant here? Do you wish to submit? No questions. I don't even have, no questions. Submitted. O'Mahony versus Whiston is submitted. People versus Kibler, appellant. Submitted. Cooney versus City of New York Department of Sanitation, appellant. Respondent? 5, 1, and 5. Bolson versus UJA Fed Properties, appellant.
Appellant 5 and 1.
Respondent?
Respondent 2 minutes, Your Honor.
5 and 1, 5 and 2. Peter Nelly versus Smiley and Smiley. Respondent? 5, 1, and 5. McWilliams versus A.O. Smith Water Products, appellant.
Appellant Thomas Carruthers, request 12 and 3.
Respondent?
Respondent request 10.
7, 1, and 7. Herald Center versus Shegol, appellant. Respondent? It's nice that you're sitting together. Spark Logistics versus Shows, appellant. Respondent?
Is respondent appellants Harlan Lazarus 5 and 1.
5 and 1. You have a cross appeal?
Yes, Your Honor.
5 and 1 and 5 and 1. People versus Soto, appellant.
Good afternoon, appellant request 6 and 2.
Respondent? 6, 2, and 6. 93rd Building Corp. versus Hefty is submitted. 111 West 57th Holdings versus U.S. Crane. Appellant? Respondent? 5, 2, and 4. People versus Erica Woods.
Good afternoon, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant. I want to start by emphasizing, I think, 4 main points on our jury note point in this case. First, the trial court's decision to not respond to the jury's request for the defense summation did not implicate the trial judge's discretion about the content of a particular response to a jury note. Rather, it involved the non-discretionary duty to provide some meaningful response.
Why wasn't it a meaningful response, what the judge did?
Because what the judge did was initially tell the jury, yes, I will provide a readback of the defense summation. Then when a verdict came back, without having informed the jury, without having fulfilled that request, the judge took the verdict without making any inquiry of the jury.
By the jury coming back with a verdict, knowing that its own request had not been fulfilled, isn't that an indication that they no longer needed what they had asked for?
Absolutely not, Your Honor. And I want to point the court directly to footnote 5 in People v. Parker, where the Court of Appeals expressly rejects this idea of a verdict amounting to an implicit withdrawal of a previous unresponded to note. The Court of Appeals has squarely rejected the implicit withdrawal.
What's your position that once a jury asks for something, they must, under all circumstances, get it?
Yes, there are two core duties of a court in responding to a substantive jury note. One is to give meaningful notice.
It's a meaningful notice, and didn't the court do that here? Because the court did tell them that it was going to provide the readback. But it appears that what happened was that the court reporter was doing double duty, as is often the case. So it wasn't an issue, at least how I interpret it, that the court refused to provide them the information. It's just that it hadn't gotten around to it by the time the jury came back with a verdict.
Exactly, and that's exactly what happened, for example, in People v. Laredo, an old 1987 Court of Appeals case where the court told the jury that it would provide the requested readback. A verdict comes back, and the court makes no inquiry, and the Court of Appeals said that's not a meaningful response because it's no response at all. There's no difference here, Your Honor.
The readback was for the summation, correct?
For defense summation, yes.
We all know that it's pretty well settled that summations is not evidence. It's just what one side wants the jury to believe has been marshaled here, correct?
Correct.
And the jury took an oath to follow the evidence, correct?
Correct.
And the jury's given an actual instruction that specifically says that opening statements and summations, all of that stuff is not evidence. So against that backdrop, where is the reversible error? It's harmless error maybe, but not reversible error under these circumstances, and why do you disagree?
So I guess a couple points about that. Let me just, I guess, in terms of the harmlessness or prejudice point. Also, footnote 5 in Parker, the Court of Appeals expressly rejects the idea that this serious prejudice requirement from older jury note cases like Laredo and Augusto. They specifically reject that that's no longer required. The dissenting opinion in Silva had talked about Laredo and Augusto still require serious prejudice, but the Court of Appeals majority rejected that, and in footnote 5 in Parker, they again reemphasized serious prejudice is no longer part of the inquiry in a jury note case like this where there's no meaningful response. And they specifically identified Laredo and Augusto were no longer following the serious prejudice requirement. In terms of the content of the jury request here for a defense summation, the relevant distinction in the jury note ORAMA 31030 case law is between ministerial requests and substantive requests. This was, without any question, a substantive request. And that triggered the court's core ORAMA duties, which includes a duty to provide a meaningful response to all substantive jury notes.
Are you interpreting meaningful response in this case to be nothing less than the readback of the summation?
No, I think like cases like Laredo show and cases like Max show, the court could have satisfied its meaningful response duty when the jury came back with a verdict, just making a simple inquiry. This is what the court said in Mack and Laredo. Could have inquired about whether the jury still sought the unfulfilled material. That would have fulfilled the meaningful response. The court didn't do that here. And that's exactly what the court said in Laredo is not a meaningful response and was reversible error. I guess just a couple quick points on prejudice. Again, I think from footnote 5 in Parker, there is no longer any serious prejudice requirement in this context. But even if there was, which we would point that we very much reject, and we think the Court of Appeals has rejected, even if there was, this was prejudicial. This was the most defense-favorable material that could have been provided. There's certainly no bar on providing a summation.
You're saying that the summation is the most favorable material? What about the evidence?
Well, fair enough. It is, without any question, defense-favorable material. This was very much a substantive request. It wasn't like the ministerial note in a case.
Counsel, the request was made at 4:30, correct?
Correct.
The court said he would get back to the jury the next day. In the morning, he told both attorneys he planned to read back the summation, correct?
Correct.
But the court reporter wasn't available.
Correct.
In that time frame, a verdict comes in. It's not like the judge wasn't trying to do what he said he would do. Was he supposed to tell the jury, no, we don't want your verdict? Don't you want to read the summation?
So, Your Honor, with respect, the Court of Appeals addressed this very issue in People v. Laredo. And there was a 3-hour delay. The court reporter wasn't available to transcribe the requested testimony. And the court said, still, in that circumstance, even with a verdict, they were waiting for 3 hours. The court had to at least make some inquiry about whether the jury still sought the requested material. And because the court didn't make any inquiry, it was no response at all. It didn't fulfill the meaningful response. It doesn't matter whether everyone, like for example, the court reporter was acting in good faith. This was expressly addressed in Laredo, Your Honor. Thank you.
May it please the court, Noah Shamoy for the people. Your Honor, I would like to just read from page 1494 of the record when the court, before the verdict was reached, after having responded to all the other jury notes, said to the jury, we would also give you, if you still requested, a readback of the summation of the defense. That was the last comment made by the court, and by definition, that is a response to a jury note. Nothing more needed to be said, nothing less. The court was saying, I've given you everything else you've asked for. It's been days of deliberations. If you still request that original request from day one, I will give you the summation.
So this is not a case where the court just ignored the jury note. There
Correct.
was a response.
The court
just
gave a
didn't get
meaningful
to it.
response, and that is the definition of a meaningful response. And there has never been a court of appeals case, or indeed a case in any court, that has found the failure to give a summation to be reversible error. There's none reference in their brief, and in fact, the trial court itself, in deciding that it would give it to them initially, said through its search it could not find a single one, and respondent has found none either. In every case, it was either not an abuse of discretion, or in the sole case where it was found, I believe, by this court, it found it wasn't reversible error because it could not have possibly prejudiced the outcome given that it was summation testimony. Now, if the court has no further questions, we ask that you affirm.
Well, I do have a question with regards to the defendant's motion for a mistrial based on the introduction or the discussion of the heroin on the co-defendant.
Yes.
Should it have been granted?
Absolutely not, because
not?
it was the defense who first requested that those charges be dismissed. It's a waived and unpreserved claim. But in addition, it had no spillover effect whatsoever. The court itself conducted a lengthy analysis of why it was that it was legitimate testimony to be elicited in that case, because there was more than sufficient evidence to make out the charges when read in a light most favorable to the people. And there were, I believe...
What was the evidence that the defendant possessed the heroin?
It wasn't. It was an acting in concert, purely circumstantial charge, which is actually one of the reasons why the people didn't want to go forward with it, was because it would have changed the reasonable doubt standard, and would have risked the direct evidence of the sale. The evidence was that this was her steerer, and this individual was the, as the court put it, although not eloquently, the heroin seller, and she was the cocaine seller when anyone came to them.
But even if that's the case, how is the heroin attributable to the defendant?
Well, in this case, he brought the two buyers to her directly, then left the location and acted as her lookout. And then when she came out, realizing that it was an undercover she just sold to, she turns to him and yells at him.
No, there's no doubt. I'm not disagreeing with you that there is ample evidence to suggest that the co-defendant was the steerer and acting in concert maybe to sell the cocaine. But the issue is the heroin.
Correct. So the only thing that those two buyers requested was cocaine. And the theory is, and it was a legitimate theory that was presented and that the court adopted, is that they were basically acting as a pair, and there was a reasonable inference that they were a pair of sellers, one of whom was selling the heroin to any buyer who would come along asking for heroin, and she was asking for the cocaine.
Under your theory, had the undercover requested heroin, the co-defendant would have sold it.
Correct, because that's what was on the co-defendant at the time. Now, there is the possibility additional evidence, in fact, it seems likely additional evidence was presented to the grand jury that further established the connection, and the reason for the dismissal was because that further evidence was not elicited when the undercover took the stand as the last witness. And that would further explain why it is that it came to the people asking for the dismissal. If the court has no further questions, thank you.
I think just a few quick points in rebuttal. First, 1494 in the trial transcript is not the last reference to the request for the summation in the record. In fact, it's at page 1500, where right before the court excuses the jury for them to continue deliberating, he tells them, we'll bring you back when you're ready to read back the to you the testimony that you have saw, and the other, which you also want, which was a reading of the summations. The court told the jury that the summation was coming to them, and then just never provided it. It's on 1500. 1494 is not the court's last reference to that. In terms of the fact that this was a request for a summation, again, the relevant distinction in the jury note in ORAMA and 31030 case laws between substantive and ministerial notes. This was a substantive note, a substantive request of the court, and a court's failure to respond at all, just like what happened in Laredo, to a substantive jury note, is a default on its duty to provide a meaningful response to all substantive jury notes.
Thank you.
Thank you.
Zito Group versus Baker.
May it please the court, Gregory Skiff, on behalf of the appellants, Zito Group LLC, Tibrio LLC, and Stefan Goss. Good afternoon. This appeal really comes down to two primary issues. The decision of the lower court determined that an extension under CPLR 306B, which requires the affidavit of service, or that the complaint rather be served within 120 days of the filing of the complaint, be extended, and also with respect to the service that was made under CPLR 3082 that said...
Counsel, it's undisputed that the service wasn't good because there was no mailing. How have you established the reasonable diligence that's required for either of those exceptions to apply to give more time?
Your Honor, on the underlying motion, our papers in support established that we took reasonable efforts through the process server to locate the defendants and to try to serve the defendants. We also explained to the court all of the ways in which the defendant had tried to evade service, which is what prolonged service and why he wasn't served. And also, Your Honors, we did, in fact, effectuate service, which is, I think, the primary error of the lower court, where she found in her decision that the second service that occurred, admittedly, after the 120-day period had expired, did not contain the requisite mailing, and it did, and the affidavit of service that was submitted to the court showed that. And so it was on that basis that actual service was, in fact, made, albeit after the 120 days that the service under the interest of justice standard that she could have applied should have been extended.
Maybe I'm confused. Wasn't the part of your evidence to show due diligence involved a paper trail in pre-complaint?
Well, there were efforts.
And secondly, it was supported by an affirmation by an attorney on information belief, which we generally require someone with personal knowledge to go through all the steps, and it was really an attorney who was going through all the steps as to how Powers was arguably being evasive until ultimately there was service, as you described, the second time around after the 120 days. Isn't that on this record? So
yes.
How does that support due diligence for interest of justice, for an interest of justice exception?
The efforts of the process server, of course, the attorney affirmation that was submitted in support of the efforts was not based on firsthand knowledge and was based on information of belief. That is in the record. However, the efforts of the process server were at the direction of that attorney, and the ultimate service that was effectuated was based upon a sworn affidavit that shows that mailing was in fact made, and the lower court in the decision specifically states that the second service did not have the requisite mailing, and that's simply a factual inaccuracy in the decision. And I think had the court understood that the second service had been diligently effected in the interest of justice, the extension should have been granted. We're only talking about a difference of a couple of months.
I'm sorry, do you have another question?
Just the merits here, malicious prosecution. We have a contract that's indisputed that had the mandatory arbitration clause and involved mandatory arbitration in California, where the client was actually based in San Diego. Everything was California. And the fact that you have a clear contract that mandates arbitration, how could it possibly be malicious prosecution?
Well, we believe, Your Honor, again, the fact that the lower court failed to enter into the contacts analysis and look at the extensive contacts with New York. Yes, the arbitration, we concede the arbitration
Counsel,
took
why
place in
wouldn't we just
California.
apply the black letter rule, basically, which is that you look to the state where the arbitration took place to determine what law to apply?
Well, we believe under the restatement second conflicts of laws analysis, there's an exception to that black letter rule, and that's where the contacts are so extensive as to dictate that the law of a different jurisdiction should apply. And here, we believe that's New York. And I would just defer to the argument in the brief that goes through all of those different contacts that were with New York that would lend itself to a finding that New York law applies and not California law. And again, the fact of the matter is that the lower court failed to entertain that analysis. She just looked at that first general rule, but she failed to go through the analysis required under the exception.
Okay, let's hear from opposing counsel.
Thank you.
May it please the court, Neil Klausner, Davis, and Gilbert, on behalf of respondents Baker and Hostetler and Mark Powers. I'll start with the second issue that was just discussed, and that is the black letter rule under the Court of Appeals decision in Heaney that the law of the state where the underlying proceeding occurred is the law that applies for malicious prosecution.
What about his argument that there are all these significant contacts with New York that make New York a more appropriate forum?
Right, two answers to that. One is there is absolutely no record citation that supports the allegation that there were New York contacts. That was something that was actually raised for the first time in the appeal briefs, but the record in this case does not support any New York contacts. Second, there is no precedent in New York for the law of any state other than where the underlying proceeding occurred to apply in a malicious prosecution. No precedent whatsoever, and appellant hasn't cited any, and we're not aware of any. In fact, nationwide, this is a standard
You're
rule.
saying that that restatement rule doesn't apply in New York? Is that the argument that you're making?
The rule that
The restatement does articulate an exception to the rule that it's the locale of the arbitration. Are you saying that that restatement rule doesn't apply in New York?
I'm saying that the Heaney v. Purdy is the governing rule, which provides that it would be almost unthinkable for any other, that's the language of the Court of Appeals, for any other state's law to apply.
What about Tripodi, which I know is a federal case, but doesn't that sort of incorporate the restatement rule into New York law?
The restatement itself says that the law of the jurisdiction where the underlying proceeding occurred shall govern, except in a rare case, which, by the way, no such case has come up in any of the precedents, a rare case where all of the parties reside in New York, the transaction at issue occurred in New York, but a proceeding was brought in some other state to interfere with that transaction. We have none of those connections.
It's going on a little bit of a side thing, but doesn't Tripodi state that you look to the most significant, that there is an exception for significant, connection to another state to apply the other state's rules, in limited cases?
In an unusual case, the restatement gave the example that I was just trying to paraphrase, and that is where the residents of the parties are all in New York. That was not the situation here. And the underlying dispute concerned an activity in New York, which was not the case here. There could be a rare exception, but that exception has never been cited in any, it has never occurred in any case in New York or anywhere else as far as we can tell. So the standard rule, Heaney v. Purdy, which has been followed by numerous New York cases cited in our papers, is that you look to the jurisdiction of the underlying proceeding.
Okay, do you want to address the service issue?
Sure.
Reasonable diligence issue? Yes,
I think Your Honor has identified the problem was the lack of due diligence. There was never a motion for an extension of the 120 days. The 120 days came and went without a mailing, and it was only 3.5 months later, in opposition to our motion to dismiss for inadequate service, that a request for an extension was made in the opposition brief, and the court said that reflected a lack of diligence, that there should have been an immediate request either before the 120 days expired or shortly thereafter, not 3.5 months later, when in the context of a brief. There is no admissible evidence to show that any efforts were made to complete the service within the 120 days. There was the hearsay affidavit of the lawyer, but no affidavit from the process server.
Thank you.
Thank you. Thank you, Your Honors.
Just a couple brief points for rebuttal. The underlying record that was presented to the lower court contained a variety of references to the context in New York. Obviously, when the complaint was drafted, it was not drafted for the intent of conducting a choice of laws analysis. So there weren't specific references in every paragraph, but there were the references in the paragraph of the complaint, paragraphs 15, 19 through 20, 68, at the record 17 through 59, which establish the parties' connections to New York. And so that's what we feel had the court conduct. Again, our point is not that the court incorrectly applied the analysis, it's that the court failed to apply the analysis. Had the court applied the analysis, those allegations in the complaint would have been looked at, analyzed, and considered under the factors.
But would you agree that it would be rare for a state other than where the underlying proceeding took place to exert jurisdiction?
Yes, I agree that it would be rare, but however, in this
Why should this be one of those rare cases?
because the only connection to California was merely that that's where the party selected for the location of the arbitration proceeding.
Isn't your malicious prosecution claim premised on Baker and Powers' alleged abuses in the arbitration proceeding in California?
It's the commencement of it, but the fact that the underlying the underlying claims and the facts and the location of the parties, everything was tied to New York, and that's further. I mean, even the Samples LLC operating agreement defines a business day according to New York, New York. The principal place of business is down the street at 335 Madison Avenue in New York.
You also filed in California, didn't you?
I apologize.
Didn't you file an action in California as well?
There was an action filed in California.
By you?
No, not by me, not
By-
by the appellants. Yes, Your Honor. But that action was dismissed, and an action was then
And now we're
filed
in New York.
Yes.
Thank you.
Thank you.
People versus Kibler? Oh, I'm sorry, that's submitted. Cooney versus New York Department of Sanitation.
Good afternoon, Your Honors. Richard Soto for the appellant. In making the determination that the defendants had established that there is no reasonable accommodation which would allow plaintiff to fulfill the core duties of the job of sanitation worker, the lower court essentially turned the analysis required under summary judgment on its head and gave every favorable factual inference in favor of the defendants rather than the plaintiff. And there are really three core pieces of evidence in the record that shows there is actually an issue of material.
Let me ask you a very specific question about the evidence. We have Dr. Obis saying that the gloves are not an adequate accommodation, that it's just going to exacerbate the condition. And then you go to look at plaintiff's or petitioner's expert who doesn't address the gloves at all. So how did that opinion rebut the opinion of the sanitation department that this would not be an adequate accommodation?
Well, Dr. Obis's memorandum came after the initial rejection of Mr. Cooney's application on medical disqualification grounds that he had the psoriasis. He then submitted the note from Dr. Tarsus, and at A71, we have an affidavit from Dr. Tarsus more fully explaining her reasoning behind that note.
Where does she address the gloves and the use of gloves as a reasonable accommodation?
Well, we would submit the accommodation that was requested was continued treatment of the condition
how
with
is-
topical medication and Enbrel,
How is
and that the gloves is besides the fact.
How is continued treatment with medicine an accommodation that the employer would give as opposed to just something that the potential employee would do. How is that an accommodation? That's not anything you're asking the employer to do as an accommodation to continue using creams.
Well, the law doesn't exclude treatment as a reasonable accommodation. Most accommodations are carried out either in consultation with a physician or by an employee or a prospective employee
But Counsel,
on their own.
I'm confused as to how that's an accommodation. Presumably, that treatment he was going to undergo, irrespective of whether he got this job or not, right?
Correct, but it's but it would allow
There's
him to
nothing that
perform the
sanitation
essential.
could do. Sanitation wasn't telling him you couldn't continue this treatment, right?
No, they were not, but they were saying but the opinion of Dr. Obis simply speculated that in the future, the psoriasis would return, and we have the note, the affidavit from Dr. Tarsus and the note indicating that with treatment, that would not be the case.
That with treatment, it's a chronic condition. It doesn't go away, right?
Correct.
So Dr. Tarsus didn't really address the potential chronic concern that the Department of Sanitation had with respect to someone with this condition being exposed to so much toxicity in the workplace, possibly getting an infection, jeopardizing the worker's health and ability to work. Dr. Tarsus' affidavit did not address a long-term, don't worry about this is really latent, no problems.
Correct, Dr. Tarsus didn't
So,
address the
isn't-
speculation,
don't
but the
you think-
speculation by Dr. Obis.
Sorry, I just want to finish the point. Don't you think that's a critical factor here? Because that is exactly what Dr. Obis or the Department of Sanitation's position is, that you have a condition that could affect your ability to be an effective sanitation worker. It would be your burden to come back and say, no, it's a condition that can be latent, under control, will never flare up, or whatever it is that you would want to say to convince them that this condition would not interfere with his work. But that affidavit by your expert did not, or by your treating physician, did not do that.
I would submit there is an open question under the New York State human rights law where the burden lies in terms of determining whether an accommodation is reasonable
not
or
an
not,
accommodation.
or an undue hardship. And certainly under the New York City human rights law, and the Court of Appeals has weighed in on Manila in this instance, the burden is on the prospective employer to demonstrate
Nothing
that.
you've shown that they should do to accommodate him. Gloves would be something they could do, but his continuing treatment is not something they could or could not do. It's something he does.
Well, I would
Why-
submit.
Where are you saying that they refused to give him an accommodation that they could give him to make him be able to perform the work safely?
They refused to permit him to enter in the job of sanitation with the accommodation of continued treatment on the speculation that the psoriasis might flare up again in the future. And I would submit that.
Let's hear from opposing counsel. You have rebuttal time.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for respondents. Our position, I think, is pretty detailed, laid out in our brief, and I don't want to rehash it here, so I just want to, if Your Honors have any questions for me, I would be happy to answer them. But if
And did you consider his continued use of medications and accommodation?
they didn't, there was in Dr. Obis's note, there was a concern that even when a topical cream or other type of treatment can, in a transient sense, help alleviate symptoms, that psoriasis is chronic. It never goes away. It becomes latent, and it can then reoccur. So in that sense, yes, it was addressed.
Any other questions? Okay, thank you.
Thank you.
Just one brief addition, Your Honors. The Court of Appeals recognized in Jacobson v. New York City Health and Hospitals Corporation that when the New York State Human Rights Law was amended, and I will quote, "The legislature enacted this more tailored approach in response to judicial decisions which had insulated employees from liability based on the mere possibility, however speculative, that someone with the claimant's condition might become unable to perform certain job functions." That's exactly the analysis that Dr. Obis offered in the memorandum when he rejected the plaintiff appellant's proposed accommodation, the continued treatment of the psoriasis, which was in remission at that point.
Counsel, but in that case, didn't the employee request specific accommodations? And here, did your client request?
We would submit that the note from Dr. Tarsus was a request for accommodation, and that under New York State human rights law, there is a notice that once an employer or prospective employer is on notice that an employee has a condition or a prospective employee has a condition, they are then under the obligation to engage in the interactive.
I just want to clarify something. When you say that the note should be taken as a request for an accommodation, are you saying that the Department of Sanitation should give him the topical cream?
No, I'm saying at that point
They should what? They should let him put the topical cream on? They can't stop him.
They should have engaged in an interactive process to see if that request of accommodation would have addressed any concerns that they had in terms of Mr. Cooney being able to perform the essential functions
I
of
guess
the
what
job.
I'm having an issue with is I don't see the accommodation.
The accommodation was the treatment of the condition, Your Honor.
Which he was getting and sanitation could not stop.
Correct.
Okay.
Thank you. Olson versus UJA Fed Properties.
Good afternoon, Your Honors. May it please the Court. Michael Zhu, Appellate Counsel to Morgan Levine Dolan, attorneys of record for Robert Bolson. The order appealed from should be reversed because the lower court erred in granting the defendant's motion for summary judgment and dismissal of the complaint. The defendants failed to establish their initial prima facie burden by coming forward with evidence in an admissible form establishing when the passageway was last inspected or cleaned. The evidence that they relied on, the surveillance video, which the court has a copy of, is insufficient to establish the absence of notice. Mr. Leroy, the superintendent of AWNS, testified when he was asked at several instances in the deposition whether the video showed something, whether the video was consistent with what he remembered the condition to be. And in 3 of those instances, he said that the video was grainy and unclear. So he couldn't tell, and he couldn't answer the question that was posed to him. Then in support of their motion for summary judgment, they submit an affidavit from Mr. Leroy, where he states that the surveillance video very clearly shows that there was no defect. We submit that that's a feigned affidavit that should be rejected.
In addition to that, he went about 7 or 8 times a day to smoke outside and traverse the area.
I'm sorry, say that again? In addition?
So in addition to that, then he claims that he went outside to smoke 7 to 8 times a day and traverse the area.
Yes. So that part of the evidence submitted by the owner and by AWNS establishing the absence of notice should not be accepted by the court because it's a feigned affidavit. As to Mr. Caserma, an employee of the building, he testified that he traversed the passageway, and it was submitted by the defendant in support of their motion that Mr. Caserma walked across the passageway 15 minutes before the incident and didn't notice anything, and therefore there was no constructive notice. The problem with that testimony is that page 365 of the record, Mr. Caserma concedes that he has no independent recollection of what he observed. The fact that he walked down the hallway 15 minutes before the incident is meaningless if he can't state that, and when I walked down, I didn't see anything, there was no defect, the masonite was properly taped. He didn't testify as to any of that. His testimony was, I can't remember what I saw 2 years ago. So the defendant's use of that testimony in support of their claim that there was an absence of constructive notice should be rejected. And on those grounds, the court should reverse the order and reinstate the claim. Thank you.
Thank you.
Good afternoon, Your Honors. Kevin Murtaugh on behalf of the respondent, UJA FED Properties. It's respectfully submitted, Your Honor, that the evidence does show. The only issue here is whether or not my client had constructive notice of this particular condition. We believe that
Were any logs put in? Typically, we would see inspection logs, because masonite is an important element in construction to protect the flooring, and you want to make sure that everything is lined up right every day. If you have any of that stuff that's on this record? I didn't see anything.
No, there is none. There's none, Your Honor.
So then how do you have any basis to reject, to determine conclusively that it's just, that constructive notice would not be up?
Well, I think they were there. I mean, it was used daily, Your Honor. You know, what I'm saying is that people traverse that area daily, and the surveillance film shown that even the plaintiff crossed it daily. The problem with this masonite was not that it was dangerous and defective throughout this.
It's the taping.
Yeah.
Making sure that it doesn't rise up to become a trip hazard or a slip hazard or something of that nature, correct?
That's correct, Your Honor. That's exactly what occurred here, though. But that's what I'm saying is that occurred. We say that the evidence is clear that that occurred right at that point in time.
But how can you establish that that's what that it shows that if you don't have anybody who looked at it at any point in time and said, oh, it's fine?
No, we can.
Somebody who looked at it in the morning or the midday or something else who said
We were there
it's
that.
fine.
I'm sorry, Your Honor. We were there right then and there. In other words,
But there's no evidence in the record that anybody on your behalf looked at it and said, it's smooth, it's fine, there's no problem with it.
No, we don't have that, Your Honor, but I say what is sufficient is that when you look at what the evidence of that night, okay, that no one was having any problems walking there. It has to be that even the plaintiff said, I didn't notice any problem with it, while I was walking out. And while you saw this.
The mere fact that there wasn't a prior accident, though, doesn't establish that there was nothing wrong with it. The mere fact that no one else hurt themselves, or else you can only ever win a lawsuit if you were the second person to hurt yourself. So that sounds very circular. I think I'm repeating what everyone else said, but where is the evidence that the floor was okay before the accident, that the duct tape was actually annexed and properly taped, and that the floor was safe?
The only evidence I can say, Your Honor, I'm not going to tell you that there's any evidence with regards to a log or anything like that. I can only say that people traversed this back and forth daily for 6 months.
Right, but is that, what case do we have that says that that's a viable argument? The fact that no one got hurt before means that there's no notice of any, dangerous condition. I don't know of any case that says that or would say that.
Well, I think, Your Honor, when you have a situation where, like the Gordon case and like the Judge Frank cited below, that when the plaintiff can't say what the condition was beforehand, plaintiff didn't know what the condition was.
Wasn't there, in fact, testimony from Lenoy that there were sections of the masonite that lacked duct tape, that the duct tape was not affixed properly, and that duct tape was something that had to be periodically replaced? It couldn't stay there forever without inspection or reapplication?
No, it couldn't stay there. It couldn't stay there without inspection or application. But I'm suggesting, Your Honor,
So is
I can only say.
Undisputed that duct tape is something that has to be periodically inspected and replaced over time, that it can't just stay there once, be put there once and stay there forever?
But no, but you have to be able to say that it certainly was defective at that point in time. And I'm saying that there was no testimony that this thing existed for any length of time, because it was being used constantly, and that night it was being traversed over back and forth. And it can only be, and the plaintiff said that he didn't see the duct tape only after the accident. And Your Honor, it was apparent that something happened to that evening. There was never any problem.
I'm having trouble understanding why that's apparent. It seems to me that the plaintiff didn't have an obligation to check the status of the masonite, but
No, he didn't.
your client did. And I think that's where the fact that he didn't notice it before doesn't mean that it was okay before, but the question is why your client didn't inspect it and with any kind of regularity or have a plan or anything else with regard to that.
Well, I do know that he was there. I do know that there was no logs, as Your Honor requested before, but what I'm saying to you is that he was there during the course of Mr. I think it was Kasema, was certainly there, Your Honor, he would frequent the place. No logs, no definite inspection. I can't tell you that, but I can tell you that he was there and didn't ignore the condition for the 6 months it was down there.
He may not, there may not be any evidence that he ignored it, but there's also no indication that he actually saw it or paid any attention to it, right? There's nothing in the record to indicate that he actually paid any attention to what
He
the
never
condition
noticed
was.
it. I can only tell you that, Your Honor. He never noticed that there was any condition like that. Okay? Thank you.
Good afternoon. May it please the court, Allison Snyder with Barry McTiernan and more for the defendant respondent AWNS Construction. The decision in order below should be affirmed, but for reasons that the lower court didn't address. It's very simple that there is no duty owed by our client AWNS to the plaintiff.
What about launching an instrument of harm, that they were the ones who put down the duct tape, they were responsible for the maintenance of the duct tape when they were present, and that therefore creates a burden on your part to show that they didn't launch an instrument of harm in the way they maintained the duct tape?
You know, this court has consistently referred to the duct tape, and the plaintiff isn't saying that there was an issue with the duct tape. He specifically said the reason why he tripped was because there was some sort of a height differential. He doesn't know what caused that height differential, and the only evidence we have before the court is that AWNS did install the masonite. They specifically said that we only tape at the seams because the weight of the masonite is firm enough to lay flat on the ground. Now,
You're saying duct tape wasn't even necessary?
it wasn't, and you know the plaintiff is.
Why'd they use duct tape if it wasn't?
Well, for the specific reason that, as Mr. Leroy said, it's to keep these sheets so that you don't have 7 or 8 sheets that could be shifting. You want one solid line that creates a walkway, which is exactly what happened.
If there are pieces of duct tape missing,
It's
doesn't that create a possibility that there's going to be an uneven walkway
No.
because pieces of the duct
And
tape
I wanted to draw the court's attention to the plaintiff's own testimony. He was asked about where he fell. He said his foot came into contact with a portion of the masonite along the 4-foot width of it. And initially he said it was at the corner. So he was talking about at the seam, at the edge. So you have a piece of masonite and a piece of flooring and then a seam. And originally he said it was at the corner. And then he specifically said at 176 at the record, it wasn't at the corner, it was inside the corner. He said it was a couple inches, 2 to 3 inches away from the edge. So the only evidence we have, the court keeps talking about an absence of tape, but there was no need for tape because, as Mr. Leroy specifically said, it lays flat on the ground. The only
Thank you.
Thank you. And I'm sorry.
Time's up. Thank you.
Thank you.
You don't even need to reset. The court has a good understanding of the argument, so I'll cede my time on rebuttal. Thank you.
Perdinelli versus Smiley and Smiley.
Good afternoon, Your Honors. May it please the court. I'm Anthony Lamberti, and I am appealing a sua sponte order of the guardianship court disqualifying me as counsel to Jose Verdugo, who is a incapacitated person.
So I understand it was a sua sponte order when it was issued in March of 2022.
Yes, Judge.
Sorry.
Yes.
And it was then reduced to writing in July of 2022, correct?
That's correct.
And so presumably before you went into court or virtual court, did you have a notice of appearance or anything else?
I had filed my notice of appearance on December 10, 2021.
That's not in the record, is it?
No, it's not.
Okay. In fact, I couldn't find anything in the record that you had submitted to the court prior to March of 2022 with regard to your representation of Mr. Verdugo. Is there anything in there?
Well, Judge, I filed my notice.
But it's not in the record, so we can't consider it, correct?
At the time that file was sealed, and there's reference made in the order of the judge, the guardianship judge, that I should have known of her order issued the day before.
Wait a second. Your record on appeal to us doesn't include the notice of appearance which you claim you filed in December of 2021.
That's correct, Your Honor, yes.
So we can't consider that that exists, right?
Well, it is referred to by the judge.
Let me turn that around. From my point of view, if it's not in the record, I can't consider it. So I don't see what it is that you want us to use as a basis for concluding that Judge Sharp was wrong when she said you couldn't appear.
Well, what I'm saying is that she had my notice because she references it.
But we don't have the notice.
I understand
So
that, Your
we can't consider that.
Okay, so basically what you're saying is that the alleged incapacitated, the incapacitated has no right to.
No, I'm not saying anything about I'm not talking about the alleged incapacitated person's rights to have counsel. What I'm talking about is our ability to review the record that was before the court when she issued her order in March of 2022. And you're telling me we should consider a notice of appearance, but it's not in the record, so I can't consider that. So what is it that I should be considering since that's not in the record?
Well, what I'm asking the court to consider is the fact that I did appear in the lower court, and the judge did not consider.
But if you haven't filed a notice of appearance, why should she permit you to appear?
Well, I did file the notice of appearance, Judge.
Well, let me move on to a different topic in this context. Was there anything in the record that reflects your retention by Mr. Verdugo?
Mr. Verdugo, other than my filing and the reference in the order by the judge.
In other words, I assume as an attorney, you would have a retainer agreement. You would have, you're meeting with someone in your office.
I did.
Sit down, someone signed something, and you tell them your billable rates, and the usual drill.
I did have a retainer agreement with Mr. Verdugo.
Is that in the record?
It's not in the record, and I'm appearing pro bono for him.
I understand that. So why would you not include something like that to show that the incapacitated person retains you?
Judge, I think this was to me, this is so preliminary or so fundamental of an issue that the judge recognized that my notice of appearance was on file and was not accepting it. Now,
But your retainer letter is also rather fundamental, and that's also not in the record before us.
It is not.
Or apparently, I don't even know if it was before Judge Sharp, was it?
It was before Judge Sharp, yes.
How do we know that? Because it's not in the record, right?
It's on the record. It's in her decision
Notice
also.
of no, the retainer letter, I don't believe.
No, the
she
retainer
ever
letter is
refers-
not there, Judge, no. Again, I think the judge did not consider Mr. Verdugo's rights to freely and independently choose his counsel, which everybody who appeared recognized that I was there except for Judge Sharp. And I endeavored to represent him. I even filed an order to show cause and petition that the Supreme Court sent back to my office, and they didn't accept it prior to my
And
disqualification.
that order to show cause didn't append either the notice of appearance or the retainer letter either, did it?
No, it did not. And Judge, the point I want to make about this is the lower court had sealed that record.
That didn't prevent you from attaching other documents to your order to show cause, right?
That's correct. Thank you.
Thank you.
Good afternoon, Your Honors. If it pleases the court, I'm the respondent, special guardian, and I believe the court has full understanding of the court's not considering Mr. Lamberti's retention. If there's any
Let me ask you a
questions, I can
question.
answer.
If Mr. Verdugo had asked his counsel to file a motion to vacate the order of guardianship, and his counsel had refused to do that, and Mr. Verdugo had then gone out and retained other counsel and had signed a retainer letter, and counsel had filed a notice of appearance, would you have had any objection to his new counsel showing up in court?
I believe that the mental hygiene law does not permit that.
I asked you a question. Would you have objected to counsel appearing if counsel had a retainer letter or notice of appearance after the alleged incapacitated, Mr. Verdugo had asked his lawyer to do something and the lawyer had refused to do it?
Yes, because the 8110 applies after the, applies before there's a determination of capacity. Mr. Verdugo had been adjudicated incapacitated, and there's
So
a
you're
court
saying
order.
once he's been adjudicated, no matter what whether his lawyer completely ignores everything he says, he can't go out and get new counsel?
What the statute says is that if the person who's incapacitated, if there's a power that's given to the guardian, that person no longer retains that power. And the
So
power.
how is, in that situation, if that had occurred, how would Mr. Verdugo be able to vindicate his rights?
the process where someone who has been adjudicated incapacitated doesn't have the power of the contract to retain an attorney is to go.
So therefore, that person would have no ability to vindicate their rights, even if he was fine by that point.
No, the process is to go through the guardian. The guardian is the one who has the power to make the applications to the court. In this case, that process wasn't filed. Mr. Lamberti never contacted the guardian, who at that time.
You're not dealing with my hypothetical. If he'd made that request to the guardian and his lawyer, and they said, no, we don't agree, we're not going to make that motion, Mr. Verdugo would have no options?
Well, under that scenario, then, if anyone can second-guess the court order that says that the incapacitated person doesn't have the ability to contract, any attorney could circumvent that. Any real estate agent could say, you know, I think he has.
What remedies would the incapacitated person have at that point?
Well, the incapacitated person, if there's court-appointed counsel and a court-appointed guardian who do not believe that the incapacitated person has capacity, then they are advocating and pursuing their position, and he can be heard by the court, and he can state his belief to the court. It's my experience as an attorney in this area that most incapacitated people don't believe they need a guardian. Get calls all the time from people who believe that they no longer need a guardian, they're fine. And the process that the mental hygiene law and the legislature has put in place is that once you have a guardian, the process is to go through the guardian if you've been adjudicated incapacitated and you don't have the power to contract.
Thank you.
May I just address the court on that one item? And that's exactly the point of this. Mr. Verdugo had sought as early as 2018, even though it's not in the record, from his...
Counsel, we're bound by the record.
From his counsel.
I'm troubled by the fact that you seem to think that we can reach out and read anything we want, but we're bound by the record. How can you talk about documents which are not for us?
Just if I can, could I address the point of the attorney not being able to be retained because he has a guardian and he's incapacitated? And your point is well taken, Judge, that let's hypothetically say, as you said, the guardian was defalcating money and he had to get permission to end the guardianship or take action against the guardian. The guardian would never give that authority to an outside counsel to look at what they're doing. And that's the point of this, is that all the judge had to do was make the slightest of inquiry whether or not I was freely and independently chosen. Thank you, Your Honor.
Thank you. McWilliams versus A.O. Smith Water Products, and Justice Gesmer is disqualified.
Good afternoon. May it please the court, Thomas Carruthers from Clyde & Co. for appellant Jenkins Brothers. JNOV is warranted here because respondent's proof at trial was not legally sufficient to prove specific.
Let me ask you, why isn't Dwyer, which is one of our precedents, as you know, controlling on this issue? In that case, we specifically held that air cassettes were sufficient to meet that burden, that the Court of Appeals has required that there be actual quantification, and that we specifically found that air cassettes were a way of obtaining that quantification that's required by the Court of Appeals in these type of cases.
Well, what we're focusing on is the admission of the Tyndall lighting video.
No, that was only for demonstrative purposes. Would you agree? It was made clear. It wasn't unlike when MAS analysis, when they would do it to try and quantify asbestos in the air, when your client was taking the position that it was all encapsulated in the gaskets and that no way it would be released. Tyndall lighting was there just to demonstrate. It wasn't counting, and I believe it was made clear on the record at the trial that the Tyndall lighting was just for demonstrative purposes and not part of the quantitative burden that the plaintiff had here, correct?
It was used for that purpose, but also it was a 20 to 25-minute video that was played to the jury.
I'm sorry, so is your argument that it was reversible error because they used a Tyndall video, but they otherwise met their burden of proof with their other evidence?
No.
And that was sufficient? Because you went right to the Tyndall. So I'm not sure if you're conceding the other point that the
No.
evidence was otherwise sufficient under our,
No, we're not conceding any other point. We feel that the Tyndall lighting video had zero probative value.
but again, that wasn't clearly was not being used to prove the quantitative issue of how much exposure there was. So the only argument you could really make about it is that it was a reversible error as a matter of law to use that. And is that what you're saying, that it was so confusing to the jury that the verdict should be thrown out because they got to see that video?
That's part of our argument, yes. I mean, it was so...
What's wrong with using that video to just show the amount of asbestos that is generally in the air when this type of procedure is used?
Well, using the testimony of respondent's own expert, and I'll point to the record 380 to 382, Mr. Garza, who was the expert who was testifying when the video was played, said he could not scientifically calculate.
Right, but you're going right back to what we just said. There's no dispute that that Tyndall video was not being used to quantify, and he had other concrete evidence he was using to quantify, and he stated that on the record.
Well,
so again, that argument is not addressing the actual record before the court.
Well, respectfully, I believe it is, but also in
Well,
our...
sir, let's go back to another point here. You said something interesting. You said it's not just the Tyndall lighting, it's whatever else Mr. Garza did below. Would you agree or disagree that the record developed here with the air cassettes and the totality of the testimony given by Mr. Garza, Dr. Markowitz, and Dr. Ginsburg collectively created a markedly different record than was in Nemeth?
We don't believe so, no, Your Honor, because...
Well, Nemeth, there was a real issue with the glove box, correct?
Correct.
And as my colleague pointed out, Dyer made clear that the use of air cassettes in a kind of environment to try and reenact the way the work was being performed was something that did meet the standards for a scientific expression. Would you agree with that holding?
Respectfully, no, we wouldn't agree, because even Mr. Garza admitted on his testimony that this did not simulate respondents' work conditions. He testified on the record, that 380 to 382 of the record, and he even said Tyndall lighting is not recognized under OSHA or NIOSH as a protocol to use for measuring...
But we already said that. We all, even their expert agreed with that. They weren't using the Tyndall lighting.
But the question had to do...
Let me ask you another question. How is this case different than Sasan versus Dykes Lumber, where exactly the same experts were used with very similar testimony, and we upheld that as creating an issue of fact in that case and said that would be sufficient to go forward? Why is this case any different than that?
I think Sassone is factually distinguishable. First of all, Judge Silvera denied summary judgment to the defendant in that case. That then came up here, and this court affirmed the denial of summary judgment based solely on the fact that there was a question of fact. It made no ruling on the...
So why, if they prove the things that they allege there, isn't that enough for a jury? If it's a question of fact and the evidence is sufficient to go forward, why doesn't the jury get to decide whether or not it's sufficient to allow a verdict to be obtained?
Because our position is there was...
Because you would have to show, for us to overturn the verdict, you'd have to show it's insufficient as a matter of law. By us finding in another case that these same exact experts raised a question of fact, that's clearly saying the jury gets to decide the issue.
Yeah, but the court here in Sassone didn't make any substantive ruling about the adequacy of the proof for specific causation purposes.
Well, we said it's enough to go to a jury, that if they prove the same exact things that they said here, because it's the same experts, that would be enough for a jury to get to decide the issue. So why shouldn't we let the jury decide the issue?
What the court said is all we're doing is affirming the denial of summary judgment because there's a question of fact and there's going to be a battle of the experts. That's all this court said.
You got to have the battle, and the plaintiff won with a jury.
Well,
Sir, unlike Sasan, there is a precedent with Jecken Brothers, isn't there, and their gas having asbestos and causing mesothelioma, McGlynn?
That's a trial court decision, yes.
Well, it was a jury trial.
Correct.
And their same kind of causation testimony, only I think it was less intense facts. I think it involved gaskets on a ship versus the description that we have here with Mr. McWilliams over his many years as a steam fitter. And McGlynn was affirmed by this court as well, correct?
It was affirmed, that's correct.
Same kind of quantitative analysis?
Well,
same kind of gaskets. In fact, this court actually affirmed the recklessness charge, which was done here as well, correct?
yes, we believe that case is factually distinguishable on a number of grounds.
Well, because one was a ship and this was something else, right?
And other grounds as well, yes.
Thank you. We have time for.
Good afternoon, Your Honors. Pierre Ratsky for Jim McWilliams, the plaintiff respondent. Plaintiff's experts in this case proved causation by providing both quantitative and qualitative scientific expressions of Mr. McWilliams's cumulative exposure to Jenkins valves. He was
What
a
about
30.
the argument that the Tyndall video was so misleading that this jury verdict can't stand?
Well, the Tyndall video, as Your Honors
Because it
pointed out.
conceded that it didn't really create the quantitative or qualitative analysis that's required. So why was it okay to admit it then?
Correct. And the underlying study results showed how much asbestos was in the dust that was being inhaled through these cassettes on the subject's lapels. That's where the quantitative numbers
So
came
why
from.
was it? Why should the court have allowed this video in? And why did that not then create juror confusion, since it didn't even go to the issue that had to be decided?
Well, the video was a demonstrative to show the pathways of exposure. One of the main defenses was that gaskets were encapsulated, could not create visible dust, could not create dust that would be breathed in by Mr. McWilliams. Mr. McWilliams watched the video outside the presence of the jury, and he said, yes, this is an approximate representation of my kind of exposure. So this video showed how he was exposed in these circumstances and rebutted their defense that it was an encapsulated product, it was non-friable, and it was not capable of producing dust that would have been inhaled by workers in similar circumstances. But as Your Honors pointed out, this was not the crux of CIH Garza's cumulative dose opinion. He did a dose calculation for each of the exposure categories involving Jenkins valves, so broken down by gaskets and insulation, and then subcategories for each.
Wasn't he even conservative in eliminating home exposure?
He was conservative, yes, Judge, in several ways. He eliminated home exposure, re-entrainment exposure. He assumed one exposure event per day when Mr. McWilliams, in fact, testified that he was exposed throughout each day. He only assumed 50% Jenkins work, even though Mr. McWilliams stated that 80% of his valve work was Jenkins. And he cut off the time periods of exposure, 15 years for insulation, 20 for gaskets, even though Mr. McWilliams said he was exposed to asbestos throughout his 36-year career as a steam fitter. So these were conservative figures in several respects. In turn, Dr. Markowitz compared these figures to the epidemiology, and to clarify, contrary to Jenkins's argument, he did not compare them to the OSHA permissible exposure limit or any other regulatory standard. He compared them to authoritative epidemiology, which the defendant didn't contest was authoritative, and showed that these levels were above levels known to cause disease. We also provided qualitative expressions of dose, including Dr. Ginsburg's testimony comparing the frequency, duration, proximity, and latency of Mr. McWilliams' exposures to specific subjects of studies. So this was more than sufficient to meet the burden under Nemeth. And as Your Honors pointed out, in the Sasson case, two of these three experts were involved, Dr. Ginsburg and CIH Garza. And Your Honors...
This is really an outlier case to the extent that Mr. McWilliams survived more than the 5-year limit that's been known in the literature, correct?
Correct, Your Honor. And the court below...
Which would be a basis for the jury awarding the award they gave.
Absolutely, Your Honor. And he's on borrowed time. Most mesothelioma patients don't live 2 years, let alone 5. And so he suffered for a longer time than most patients. And the jury took that into account when awarding the amount that they did. And the judge below acknowledged that unique record when affirming that award in totality. And the judge's determination should be afforded great deference on appeal, considering that she had the same opportunity as the jury to observe the witnesses, to observe their demeanor, and to consider all the evidence throughout the trial. And Jenkins suggests that an award of $400,000 total is sufficient to compensate Mr. McWilliams, and frankly, there's no precedent for that. So we think that the court's decision affirming the award in total is correct. Turning to some of the other issues, the sidebar, Jenkins argues that it's entitled to a new trial because of the mere possibility.
But they recognize, at least what I saw on the record, the jury was nowhere near where the sidebar took place to have heard that comment about alleged perjury.
Correct, Your Honor.
It's really just different members of the defense team near the witness box.
Correct, Your Honor, and that's why the court was correct to not give credibility credence to the affidavits that Jenkins produced post-trial. They didn't produce it during the trial because one of those.
Didn't object.
They also didn't object at the time.
Didn't ask the court to question the jurors.
Correct, Your Honor.
Correct?
They didn't even ask them at the end of when we spoke to the jury after they were dismissed after the verdict. They didn't ask them then either. And there's no credibility to their affidavits because, again, it was part of the trial team. There was Mr. Peratt, who was in the sidebar. There was Mr. Nadler, who was right next to it at the counsel table. And their paralegal was right behind them in the gallery on the same side with the judge facing them, whereas she had her back to the jury. So the court was correct to reject those affidavits as credible and certainly not enough to overturn the verdict.
Thank you.
Thank you.
A couple quick points. On the sidebar issue, there was three affidavits, or one affidavit and two affidavits and one affirmation submitted. And the facts were consistent in each of those statements. The judge in the middle of cross-examination of
What about that it wasn't preserved? Because if it had happened at the time, an objection was made at the time, the judge could have asked the jury, did you hear anything? But because no objection was made at the time, that opportunity was lost. So how is it preserved for us even to consider the issue?
Two things. First, the judge specifically asked the attorneys not to put anything on the record. It was close to 4:30 at the end of the day. She instructed the counsel not to put anything on the record, and she wanted to wait until there was a transcript prepared. And once the transcript was prepared, Jenkins moved for a mistrial and did so, and the court denied it. But the affidavits are unrebutted. And more than just whether the jury heard or didn't hear, this was a 5 to 10 minute sidebar, and the jury observed the judge talking to the counsel. The affidavits say that they heard the words criminal and perjury. And
The affidavit doesn't say they heard it, other people heard it. That doesn't
no,
mean the
they
jury
said
heard
they
it.
heard it. And they were equidistant from where the jury was from the sidebar. And also,
Forget it. Thank you very much.
okay.
Thank you. Herald Center versus Shego.
Good afternoon. May it please the court. My name is Jeffrey Levine for the appellant. CPL Law 3215B is wonderfully simple and unequivocal. The last sentence of that statute states, a judgment on default shall not exceed the amount sought in the complaint. With that in mind, there's just a few things I think the court should ask in order to.
So it seems like an exceedingly technical argument that you're making here. You're not, doesn't sound like you're disputing that the amount is owed. You're not disputing that your client actively participated in the inquest. You're not asserting that your client didn't have an opportunity to be heard. You're not asserting that the judgment in civil court was not res judicata as to your client. This is the only argument you're making. Why can't we then deem it to be amended to reflect the circumstances of what actually occurred, since you have zero arguments on the merits as to why that was not an appropriate amount for the judgment to be?
Well, a couple of reasons. One, the law is, on default, the complaint cannot be amended.
But isn't this a little bit of a different situation? Because the main case you're relying on, Gluck, on default, it was a true default situation. The defendant was not present at the inquest. So clearly, if the defendant's not present at the inquest, there's a very strong, compelling reason why you would not want to have a greater ad damnum, because the defendant wasn't there to contest to it and could have let it go forward as a default because they were willing to get a default for that amount. But that's not the situation in our case, where the defendant was present at the inquest, actively participated in the inquest, and had a chance to put all defenses available at the inquest.
Well, that's the point right there. He did not have a chance to put all defenses. He had not filed an answer. At inquest, you cannot raise affirmative defenses. The only thing that
He
could
had
be...
the right to put in all defenses as to the amount at issue, correct?
No. All we had the right to do was cross-examine the respondent's witnesses, which is what happened.
That's, at an inquest, you're not allowed to contest liability. You're allowed to contest what the amount of damages should be. And also, I don't know what the defense would be to the civil judgment. What defense could there be to that?
Well, there were defenses, there were various defenses we mentioned in our motion to vacate the default judgment, but we were not allowed to assert those defenses in the proceeding. We mentioned some affirmative defenses that would have been asserted had the appellant been able to file an answer.
Sir, I need to understand, and I'm confused. Are you saying that when you were in the inquest and they were seeking as part of their damages, say attorney's fees, or having to proceed...
Well, they weren't seeking attorney's fees.
They were seeking...
At the inquest, they were only seeking
rents, just...
rental amounts. This was not a legal fee hearing.
No, I understand that, but wouldn't that be additional rents that they would be... Wouldn't fees and prosecuting be...
Our position was the only thing they should have been requesting at the inquest was legal fees, because a default judgment had already been awarded on the first cause of action in the amount of $1.1 million. So our position was the only thing that should have been heard at the inquest was the second cause of action, which was for legal fees. So there were only two causes of action here. The first one was for what they call additional rent charges, and the second one was for legal fees. The first cause of action, on the first cause of action, the lower court awarded them a default judgment in the amount of $1.1 million, which is the exact amount they sued for.
Counsel, let me ask you, why, under the circumstances of this case, which we've discussed already, shouldn't we allow the complaint to be deemed amended so that the full amount of the judgment can...
Well, the court can allow it to be amended, but if that's done under the precedent, the appellant should be permitted to file an answer with regard to those amended causes.
No. Why shouldn't we allow the complaint to be amended based on what happened at the inquest, not to start the litigation again? What would be incorrect about this court using our power to allow the complaint to be amended to reflect what actually occurred at the inquest?
That would violate...
Let me just add on to that, essentially to conform the pleadings to the proof.
Right. That would violate the clear language of 3215B.
Why?
Because 3215B says, on default, with no exceptions stated, a judgment granted on default shall not exceed the amount sought in the complaint. And in this case, and I could answer that further by saying, if an amendment is allowed, all that does is undermine, it nullifies the statute. Any plaintiff can seek an amendment and at least have a chance of undermining the statute. The statute is...
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Jonathan Lynn from Oved and Oved on behalf of the plaintiff respondent, Herald Center Department Store of New York.
So following where counsel was arguing, why should we permit an exception to 3215 when it's pretty clear as written?
Well, it wouldn't be an exception, Your Honor. 3215, the case law discussing this issue confirms that it only applies where a plaintiff either fails to move to amend the complaint at all or doesn't give notice of the additional damage to the defendant.
I don't think that's what it says. It's not where a plaintiff doesn't move, it's where it's not granted. That's the problem.
Well, relief
That
was.
For you to get more, you have to amend the complaint. It doesn't mean you just have to move to amend the complaint. You actually have to get it amended.
Well, we did amend the complaint. The trial court granted our motion to amend and for a default judgment on February 28th, 2022. That's on page 274 of the record, is that order. And when he granted that motion, he entered a judgment on the amended claim and directed the parties to proceed to an inquest to determine the total liability owed on the remainder.
Yeah, but that wasn't for the amount that was awarded, right? That was for 4 million, I think?
Correct, Your Honor.
So there never was a motion which was granted to amend the complaint for what was actually awarded.
Correct, Your Honor, but as Your Honor pointed out, the court has the authority to deem it amended. And then the important issue here is that, as Your Honor's pointed out, Mr. Chagall has had ample notice of the damages that we were seeking throughout this trial. This isn't a scenario where, in a relatively straightforward default, you ask the clerk to enter a sum certain or the defendant doesn't show up.
About the language of the CPLR, which says when it's on a default, you can't grant more than what was actually allowed in the complaint or what was amended. Why shouldn't we enforce that provision?
Well, a couple of reasons, Your Honor. First, we essentially, in asking the court to give res judicata effect to the separate judgment that we obtained against the tenant in the related landlord-tenant lawsuit, that essentially was asking the court to amend the pleadings to the
That's a separate issue. The one issue is whether or not you're entitled to the amount. And they don't really seem to be arguing that you're not entitled to the amount. Their argument's very narrow. It's limited to, this is just not procedurally allowed in the CPLR. So I don't really see how res judicata does or does not play into their argument. Although it would certainly play into the merits of what you're entitled to.
Right, Your Honor. Well, it's worthwhile, I think, to take a look at what appellant is citing for this proposition. They requested this opportunity to essentially put in an answer and redo the entire lawsuit if the complaint was deemed to be amended or whatnot. And they rely on the Second Department's Recon Car Corp case. But what's notable there is that the appellate division specifically allowed a defendant to amend its counterclaims after a default.
But again, this is not a case where it was amended and we're now saying, was that permissible to allow it to be amended? It never was amended.
You're right, Your Honor. There was never a formal order at the end of the case saying the complaint is amended to state that the amount sought is $18 million. But as the court has pointed out, the court can deem it to have been amended. And critically here, what Your Honor pointed out was this is an extremely technical argument. And the court in Recon Car Corp, which appellant relies on to support this notion that they should be allowed to undo it and go back and relitigate the merits of the damages claimed here, even after they appeared at a 3-day inquest where they vehemently objected to and attempted to dispute their liability, is that that's an extremely technical argument that's asking to essentially obtain a windfall from a hyper-technical reading of the statute. And the Second Department rejected that as a basis for refusing to allow the defendants in that case to amend their complaint, even though it hadn't been part of the original counterclaim. The same is true here. The plaintiff is asking for a windfall of getting to undo an entire year of litigation, a 3-day inquest where we spent hours disputing all of the evidence and opposing our request for this relief. And it's entirely inequitable. What would be going on is we would be coming back to the court eventually and saying, okay, well, Your Honors, we got the $1 million judgment in the initial instance, or we got a $4 million judgment after the amendment in May of 2022. Now, the defendant has conceded liability. He defaulted there, the guarantee is enforceable, and the amount of his liability has been fixed by virtue of the separate related L&T proceeding. So we're going to be back here. The judgment's going to be the same amount. The only thing that will change is we're going to now incur more legal fees that he's going to be responsible for at the end of the day.
Thank you.
Your Honors, procedure is important. You could call it a technicality. It's procedure. There's procedure and there's substance. Procedure is very important. The procedure here is very clear under the CPLR, 3215B. I should also point out, they've cited no authority that supports their argument that the complaint can be amended. they have cited authority, but it doesn't apply. They've actually cited cases, shockingly, where trial occurred. It was no default. So that's apples and oranges. It's apples and elephants. It's not even in the same ballpark. And then the two other cases, they cited 5 in their brief. The 2 other cases support our position, where the court concluded that the default should not exceed the amount sought in the complaint. So I just want to point out, I understand he's talking about the time spent and vehemently objecting to the amounts. None of that matters. The procedure that's set forth in the CPLR matters. Thank you very much, Your Honor.
Thank you. Spark Logistics versus Shows.
May it please the court, Andrew Bronsnick from Mandelbaum Barrett on behalf of the appellants and defendants, Shoes, Brands, and Ramachandi. Your Honors.
Shoes, not shows, huh?
I'm sorry?
Go ahead.
Shoes.
I mispronounced it.
So, Your Honors, the basic facts of this case are important based on the fact that we had a summary judgment ruling and we also had a trial. And that is that the seller of the goods, Ravissant, had its rights transferred to Habib Bank. Habib Bank then sued Sparks. That lawsuit in Hong Kong was based upon the fact that as a freight forwarder, Sparks had released goods to my client based on the normal course of conduct between my clients and the seller. That was their normal custom, and there's findings from the trial court that that was the case. It's important because they did it that way. Ravissant, the seller, had agreed to allow that to happen. So now Habib Bank recognizes when they have to collect on this payment that I'm sorry, Your Honor.
And wasn't the bottom line that you then got the goods without ever having paid for them?
That is correct. So
Why is that an appropriate result?
because in 2015 and 2016, after that had occurred, Ravissant and my clients were discussing a payment arrangement. They never reached a final resolution on that due to the fact that Ravissant went out of business. The issue is, though, that these were non-conforming goods. They were late. It was clear in the record below that these were issues of fact. The reason that, sorry.
Sir, maybe I'm looking at a different record. What's before us is an appeal to determine what the damages, because in July of 2021, Judge Kelly determined or granted partial summary judgment to the plaintiff against your client, all three, Suez, Brands, and Mr. Ramchandani, for unjust enrichment.
Correct.
That was never appealed.
Right, but that was...
Just give me a second.
Sure.
That was never appealed. That's law of the case now. So now there was a trial, a bench trial, to determine how much Sparks should get. Sparks was seeking $500,000, and the court ultimately awarded the $300,000 they paid in settlement to Habib Bank. That's why we're here. So what's your position now?
Yeah, so slightly different. We would take the position that that summary judgment ruling was not a final decision. There were other open issues at the time, including damages, but also causes of action. The breach of contract claim was denied by Justice Kelly on that issue, and there were open issues that preceded.
I'm not following you. If they got summary judgment on unjust enrichment and you didn't appeal it, that's it. They won on liability, and the only issue to be tried was what were their unjust enrichment damages, and that's exactly what occurred. So you have the right to challenge the amount of damages, or that damages were somehow calculated incorrectly, but I don't understand how, as my colleague guessed, you can be challenging the actual finding of liability on unjust enrichment because you didn't appeal it.
Okay, well, I understand Your Honor's view
And that's
differently.
what the trial was about.
Right, and we argued standing in our papers, and we would stand by the position that Sparks didn't have standing originally to be granted unjust enrichment on summary judgment.
Yeah, but you should have appealed it then if you wanted to.
Understood. So I'll move on to other issues. The fact is that Sparks has alleged that our affirmative defenses were not preserved at trial, which is not the case. We had raised various issues such as unclean hands, the doctrine of voluntary payment, and other issues at the time of trial, and there was no finding whatsoever, or request by Sparks for that matter, either in limine or pre-trial, to ban or bar any aspect of our affirmative
Why
defenses.
wouldn't that go to liability as to the unjust enrichment?
It would in a roundabout way, Your Honor. So
Why even roundabout? That, it goes to whether or not your clients were liable for unjust enrichment.
right, and the findings by the
So
trial
if
judge.
if you didn't appeal it and that's the law of the case, how can you bring up these defenses at trial?
Because what happened was the trial judge simply addressed and said, okay, if Sparks paid $300,000 in their settlement with Habib, that should be the amount of money. That's what they relied upon because that's what Sparks was out of pocket. But it wasn't necessarily corresponding to at Sparks's defense. Sparks got sued by Habib Bank for their own misconduct, having nothing to do with the goods. The judge could have considered those issues as part of our affirmative defenses, but did not, and instead just had an easy approach in terms of awarding Sparks the $300,000. That should have been considered as part of our affirmative defenses.
What was Sparks' misconduct? That they gave you 7 shipments without you paying for it?
That they released it without the bill of lading.
Thank you.
May it please the court, Harlan Lazarus for Sparks. With respect to our appeal, we believe that the award should have been predicated on what the defendant was unjustly enriched, which was their selling.
Was only out $300,000, correct?
I didn't hear your.
Your client was only out the $300,000.
That's correct, Judge.
So why should they get a judgment for more than that?
Because the measuring stick is the amount by which the other party, here the defendant, was unjustly enriched.
Unjust enrichment, it's an equitable doctrine, and it means that you unjustly enriched at the expense of another. So you have to show both sides of the equation, not just how much they got, but how much you lost that you should be able to recoup back.
Well,
so what's the argument that you should get back more than what you actually lost?
Because when the goods were released without the bill of lading, we then asked to give us the goods back. My client, and that's the basis for the request for the interest fee judgment, we asked in 2016 to get the goods back. And certainly, there's no record on this, but in principle, we could have sold the goods to these retailers and gotten the same amount of money.
The loss that you're recouping here, or that the reason they were unjustly enriched is because, allegedly, because you had to pay the $300,000 to settle this lawsuit. So since that is what actually happened, and that is what you're recouping, and that is what your unjust enrichment claim is based on, why should it be the amount that you're entitled to recover from the time that you actually had to make that payment?
Well, I think you changed the topic from as to when we made the payment, but going back first to the question of how much. As I said, Your Honor, had the goods not been released, my client would have had the bill of lading, or Ravissant would have gotten the bill of lading, and the goods could have been resold by my client to this retailer.
That unjust enrichment is equitable. It was never the intent that you were going to have these goods and be able to sell them yourself. The intent was always that you were going to release the goods and get the money for the shipping.
Understood, but please bear in mind, as the court observed earlier, right, the net effect of this $300,000 award is that the defendant, who never paid for the goods at all, reaped the benefit of $212,000, or arguably $212 less whatever the credits were.
That's only because that's the amount you chose to settle for. That.
No, Your Honor, they sold the goods to retailers, and they received $438 some odd thousand. So that the party that never paid for these goods at all, irrespective of that, still got an extra $138.
You weren't harmed in that amount because the only thing you were out of pocket for was the $300,000.
Well, Your Honor, that as I said, we were harmed to the extent that had the goods not been released, we could have made the corresponding sale to the same retailers. We had a lien, we had a carrier's lien, or here it's a
loss of profits is not really unjust enrichment, though. I mean, that would be a real leap as to what unjust enrichment meant, which is basically what you're arguing, that you could have made profits somehow by not releasing them, and you didn't have to release them, and therefore you should get those lost profits.
Well, But more to the point, I'm arguing that there's no means or no justification under these circumstances for the defendant to walk away with $112,000 for free. And after, for our troubles.
Justification for your client to get more than the $300,000 that it settled for.
Well, Your Honor, taking into account the totality of circumstances here, the fact of the matter is that my client, under these circumstances, had to defend a lawsuit in Hong Kong and had to bring a lawsuit here in New York. So on account of all of that, our client suffered the additional detriment of the fees incurred in defending two lawsuits, or pardon me, in bringing one lawsuit here and defending a lawsuit in Hong Kong. And with those circumstances in mind, again, I asked the question to the panel, why is it that the defendant should have $112,000 that it didn't pay 1 cent for? It, defendant, put my client through this misery. And it did so because...
The client also released it, though, without the bill of lading, so, which it did not have to do. It could have insisted...
It did not have to do that.
At,
we agree.
the bill of lading.
But it did that, pardon me, Judge, it did that to accommodate the defendant who desired to have the goods released earlier so that it could meet.
Thank you. No, we understand, but I'm just pointing out that they did release it again.
I'll be brief, Your Honors. With regard to the totality of
Why should your client get $412,000 or whatever it is, therefore an additional $112,000 than was paid to the opposing party? Why should your client make that benefit?
Well, assuming Your Honors uphold the $300,000 amount, any additional amount would be profit. That was part of the entire transaction to begin with, is we have an expectation that we would have made profit or had sales of what it would have been. And had we been permitted to address offsets with Ravissant, the original seller, we would have addressed those things. The $300,000 would have been even less. And then with regard to the totality of circumstances, the trial judge found that Sparks's representative, Dagan, essentially was not credible and had offered a job to our customs agent in exchange for getting emails back to hide some of the evidence to cover up this whole thing. So there were other issues that were going on at trial in terms of what Justice Krause came to in her final decision.
Thank you.
Thank you, Your Honor.
You have a minute, yeah.
In terms of the credibility question, in point of fact, of course, I tried the case. The issue with the emails and the job offer was emails with respect to which the plaintiff, pardon me, my client sought to establish that Sparks had in fact initiated this whole process. It wasn't to do anything other than that. Those emails and questions were to establish the transaction, not to hide or obscure anything. It specifically says, and the client specifically testified that they wanted to get information on the transaction. They wanted to get to the bottom of what happened, not to hide it. Thank you.
Thank you. People versus Soto?
Good afternoon, Your Honors, and may it please the Court. Jane Merrill for Appellant David Soto. 20 seconds and 12 lines of transcript. The court below was wrong to deny defense counsel the opportunity to correct his mistake and exercise an additional peremptory challenge. The moments that elapsed afforded absolutely...
The time that counsel informed the court of its mistake, first, I don't believe that counsel gave an explanation as to what the mistake was. That's one. And the other thing that I think is important is that although it may have been only 20 seconds by your estimation, the court clerk had already called the juror as a juror.
Two things, Your Honor. He did offer an explanation. He said that he erred. That's not the detail that I understand perhaps Your Honor is looking for, but that is an explanation. It's not, I thought something else was going on, or I thought we were talking about different jurors. It's simply, I made a mistake. And he explained precisely what he wished to do. The other piece, Your Honor, is that, yes, the court clerk had announced the name of the juror, but that juror wasn't in the courtroom, that juror was not sworn. That's not a substantive legal event that the courts have looked to in deciding these sorts of challenges. Those events are more of the ilk of when other jurors are under consideration, such that prejudice could have accrued to the prosecution, or that the defense was seeking some sort of strategic benefit. Theoretically, assigning a juror to a seat just isn't that sort of event. And here, it's the absence of that sort of substantive intervening event that sets this apart from other cases. And those few seconds and the lack of such an event ruled out the possibility that defense counsel was seeking a strategic advantage or attempting to prejudice the prosecution. Moreover, as Your Honor mentioned, it's a very brief amount of time. That's not a meaningful delay, and it didn't cause a meaningful delay. Based on all of that, when there's none of these factors that courts have looked to in deciding these challenges, the court was unequivocally wrong to say that the request was untimely and to deny the challenge. And therefore, I would ask that you reverse Mr. Soto's conviction and order a new trial.
What about counsel? Did counsel waive any objection that he had when the court asked him if the jury was to the defendant's liking, and counsel say yes?
No, Your Honor. This objection was clearly preserved. It was preserved at the moment that he made the request.
Well, he did say it's over my objection, right? But then he was later asked if the jury met defendant's expectation, and the answer was yes.
That's true. That's about 75 pages later after a lot of intervening action, but that doesn't amount to waiver. The Fourth Department in People v. Rosario Boria found that just making the request preserved the objection, and that more than that happened here. He made the request. He made the request again. He announced his objection. So the fact that there was this later colloquy about whether the jury as a whole was satisfactory doesn't change that conclusion. That's exactly when the Fourth Department was ruling in Rosario Boria, what they relied on, that initial request. And just to provide an additional point of comparison, in this court's decision in Cotugno, which I believe is the most recent case, that was entirely different. There was much less back and forth about the juror in question. The defense in that case said, "I'm sorry, I have one more." The court said, "It's too late now." And then just 2 pages later, what Your Honor is asking about occurred, that the court asked whether the defense was consenting. 75 pages of transcript is obviously quite a different amount of time than 2 pages, especially in light of having been so clear about just what that objection was and preserving it. There's simply nothing more that the defense counsel here could have done to preserve this objection. If the court has no further questions, I would ask you to reverse and order a new trial. Thank you.
Thank you.
May it please the court, Malancha Chanda for the people.
Counsel, it was just 20 seconds.
Yes, Your Honor. I would like to draw a distinction between the cases cited by my adversary and also further ones by the people in our briefs, which all make clear that it's under the narrow circumstances of those cases. And in this case, sure, there was a bald explanation of I meant to. But in all of these other cases, there were actions and explanations that were credibly supported by the record. I'll give you instances. In Jabot and Rosario Boria, counsel said that he was done with peremptories, and then before jurors started being named, or at least the ones that they wanted to challenge, they interjected immediately. In addition, in both of those cases, there was an actual fuller explanation of like, I missed it in the notes. And I think in Boria, it was, I crossed out the prospective juror. So in each of these instances, the record supported the explanation and supported that it was an oversight. Here, not only was there just a bald explanation, the belated explanation that came pages later, during a Batson challenge for a subsequent juror, actually undermined the credibility of that
The
explanation.
explanation that was given at the time, that the attorney made a mistake, an oversight. Why is that not enough?
Well, it wasn't a he said I meant to, sure, but the other cases, they said that I made a mistake because I didn't have it in my notes, or I had it in my notes, I overlooked it, I crossed it out. Here, he just said I meant to, and then pages and pages later, in a different round, when he says, oh, it's the seating, which the court found specious properly, I would argue. He also says something like, I had a note for the other juror that I missed, but he did not say anything specifically about the juror here, which I think undermines the kind of explanation that you have in Jabot, Rosario Borea. Perellis is another case in which an immediate objection was made before the jurors were called, whereas in this case, he waited, and instead of just saying meant to, and he had the ample opportunity to, he was able to state his objection. He had ample opportunity to say, Your Honor, I had it in my notes and I overlooked it. The record here does not support and actually undermines the bare assertion there, and it's closer to Catugno than it is to the cases cited by my adversary, and also additionally by the people. And in that regard, the court cannot be expected to have abused its discretion with such a paltry explanation that was later found to be undermined, and especially in a case that's as serious as this and that warrants such a serious repercussion, which is automatic reversal. Here you need, for the court to exercise its discretion, you need to give the court more, or you need to have circumstances that show that it was an oversight. Just by saying that and then later I won't say he manufactured it, it was a belated explanation that directly undermined that he had it in his notes and he had overlooked it. And in that regard, to cut off the discretion of a judge to have an orderly voir dire kind of undermines the rules. And I know my adversary hasn't addressed the other 2 points, but I will gladly answer.
Your position is essentially with the other points in terms of the the identification of the defendant and the request to charge an expanded charge on identification. All of that was not preserved.
They're all unpreserved, and I do want to clarify that none of these were actually identifications. They never, no witness, all the witnesses were asked to do were to describe who they believe based on a description given to them of the perpetrator is what they saw in the video. Now, all of the cases my adversary cites, it's officers saying directly, it is defendant whom I see on the video, and that gives that weight that's improper for the jury. Here, they did nothing, and I would want to add that the court specifically and repeatedly noted that ultimately what the witness says does not carry weight. It's the jury's determination.
And at the end of the day, there was no specific request by the defendant for a specific charge
of the expanded identification. And
Correct.
understandably, because there was no identification. What he asked for was to make sure that the jury found that it was actually defendant who was the perpetrator. And once the court said that I would give that, said I understand that, and accepted it, even after the court later asked for additional requests. So unless there are other questions, we ask that you affirm. Thank you very much.
Thank you.
Thank you. I'd like to return briefly to the other cases that deal with this jury selection point. There's simply no daylight between this case and cases like People v. Vieira from the Second Department and Perales from the Second Department. In Vieira,
We say in the First Department case, it's really the court's discretion. And why did the court not properly exercise its discretion here? Since we in the First Department have said that's the test, whether the court properly exercised, its discretion.
the court does have discretion. That discretion is bounded very carefully. It's bounded by 2 things. One, whether this caused undue delay, meaningful delay, and nothing about defense counsel's objection.
That no meaningful objection was really given, no meaningful explanation was really given, and the court made the determination that that was not a meaningful reason for the delay in the objection.
The court ruled purely on timeliness here, Your Honor. So I do think that distinguishes this case. The statement of error is completely in line with what the courts in Vieira and Perales did on extremely similar records without these sort of fuller explanations. In Vieira, the only thing that counsel said was, we missed it. In Perales, the only thing that was said was that explained that he had intended to exercise a peremptory challenge. That is exactly what's here. Was there room for more explanation? Sure, there's always room for more explanation. I don't think that changes the essential points that the court is looking for here, whether this delay caused any prejudice to the prosecution or was to the strategic advantage of the defense, or whether it caused meaningful delay.
Thank you.
Thank you.
111 West 57th Holdings versus U.S. Crane.
May I proceed, Your Honor? Good afternoon. Andrew Bourne from Cohn Ziffer, Frenchman and McKenna on behalf of the appellant, 111 West 57 Holdings. This appeal concerns whether the appellant can proceed with his claims for damages arising out of the catastrophic crane failure at a project that its subsidiary owned in New York City. The respondents in this case are crane operators who indisputably failed to perform their jobs. As this court may remember, in October 2020, a storm, the remnants of Hurricane Zeta, approached New York City. Crane operators such as the defendants were warned by the New York City Department of Buildings to properly...
We're not really talking about the underlying liability here. I mean, this is a very specific argument, and it's not even the owner making these arguments, it's Holdings making this argument, which is not the owner. And the issue is what right Holdings has as not being a party to the crane contract, which it clearly is not. Where are you, what is the basis for your position that it has these...
Sure, Your Honor.
ability to proceed with this?
I'm going to get to that, and I'll get to that right now. The Supreme Court, as Your Honor saw, said that the indemnification provision for which my client, Holdings, is indisputably an indemnity. There's no dispute about that. Indemnity is a defined term in the contract and includes the owner as well as all its members, which is 111 West 57 Holdings. Now, what the Supreme Court said, so there's no dispute about that, that it is actually an intended beneficiary of the claim.
Is this an indemnification claim is a question?
Well, it is, Your Honor. So
Why, normally an indemnification, as was stated, normally an indemnification claim is someone's trying to sue me and I want indemnification from you for the suit against me. That's the classic definition of indemnification.
That is, Your Honor, and there are multitudes of instances of that in the records of this court.
That's not what we're talking about here.
What this provision is different. This provision, there's two parts of the indemnification provision that are at issue. It's paragraph 7 of the contract. You can find that in the record at page 131 to 32. And then there's also rider E to the contract, which is at record 2084. These provisions, while not mutually exclusive, in fact, the contract itself in paragraph 7 says it's intended to provide as broad of indemnification as possible. These provisions permit intra-party indemnification under the precedent set in this court.
You made a claim against me, so I can recover from you, even though we're all related somehow. That would be an intra-party. But I've actually never heard this argument before. That's why I'm a little mystified that I can use an indemnification provision to say that I should be able to get direct recovery for my direct injuries.
Well, that's exactly what the indemnification provision was designed for. It applies to losses, expenses. Those are the two primary ones that result from the defendant's actions in the contract. That's what the indemnification provision says. And that's where the court erred. The court erred that this only applies to defensive claims when this court has disagreed. is that this is not necessarily a defensive posture claim and only applies to third-party claims. It doesn't have, the language that a lot of cases decide, that this court has decided, where it says,
We'll actually jump to the third step, and we didn't get to the first two steps, was because before you could assert a direct claim, which you're claiming is indemnification, you'd have to show you're a party to the contract, you're a third-party beneficiary of the contract. That would be the first part of it. So you're clearly not, your client's not a party to the contract.
We
How are
don't-
they a third-party beneficiary?
we are an intended third-party beneficiary.
How are you an intended third?
How are we? Well, we actually submitted to Your Honor, to the court just now. There's the case Vogel versus Blade Contracting, 293 AD 3rd, 376, where this court held that a party that is an indemnity is an express beneficiary of a contract, or puts it beyond an intended beneficiary, but it can enforce its rights under the contract. There's no dispute that they are an indemnity. How else would an indemnity be able to enforce its indemnification rights under the Supreme Court's theory?
Because they would have express contract rights as an indemnity. You brought a claim against, someone brought a claim against me, you agreed to indemnify me, so I get to bring you in for a claim for indemnification under the contract.
No, we were bringing in to recover the losses, which is what the provision says. It permits an intra-party claim. I see that I'm out of
Let's hear
time.
from opposing counsel, and you'll have rebuttal time.
I thank you, Your Honor.
Good afternoon. May it please the court. Megan Brown from Goldberg Segala on behalf of the defendant respondent, U.S. Crane and Rigging. Jumping right in to this indemnification language. I guess back it up one step. We believe that the decision and order should be affirmed, and both of these causes of action brought by holdings, not owner, as you rightfully point out, were properly dismissed, and that order should be affirmed. The fatal flaw here, which permeates the breach of contract argument as well as the negligence claims, is this conflation of the relationship between holdings and owner. And holdings is not owner. It's a member of owner. Maybe it's the only member of owner, but that's an important distinction. And so then looking at the language of the contract, there's no dispute that it's not a party to the contract. It's also not an intended third-party beneficiary of the contract. And I would direct the court to—
Why is it not a third-party beneficiary?
Well, I would rely on section 22 of the contract, which is at page 138, which states that nothing in the contract creates a contractual relationship between the owner or any of the indemnities and the contractor. And holdings only sort of relationship here is as a named indemnity under the contract.
What about their argument that as a named indemnity under the contract, they have a right to assert a direct claim for what they call indemnification?
Right. And I would say that is incorrect because the language here, there's nothing special about this indemnification language. This is typical indemnification language that every construction contract contains. It is intended for third-party claims, not direct claims. And this requires the analysis set forth by the Court of Appeals in the Hooper case. And there has to be unmistakable clarity of an intention to permit direct claims in that indemnification language. And so despite the breadth of the language, and that might be great if you're talking about a third-party claim, but there's nothing that is unmistakable, gives that unmistakable clarity to any intention to permit intra-party claims. And that's the distinction between the language here and in Hooper and in the Shaw case that the appellant cited in their reply brief. And with respect to the Vogel case that was just handed up today, I think it was intentional that it wasn't raised in their opening brief or reply brief. It was extensively briefed in the motion below, and we believe we distinguished it there and that there was a reason it wasn't raised because I think it's pretty clear there's no third-party beneficiary status here. And unless there are other questions, I can rely on my brief for the rest.
Any other questions? Okay.
Thank you.
Thank you, Your Honors. First, able counsel here is actually 100% incorrect that the provision doesn't contemplate intra-party claims, such as the specific language in Hopper. It says, quote, this is on page 131 of the record, I believe. it has that language, the so-called special language. It says this includes, the indemnification obligation includes attorney's fees incurred by indemnity to enforce contractor's obligations pursuant to this section. That's the language that Hopper was talking about when it says that there's no right to attorney's fees for bringing in an affirmative indemnification claim. That right only exists when there's specific language. This is the specific language that's in there. We actually would meet the Hopper standard. So what we have is what we think is quite clear language, that this indemnification provision extends far beyond just the third-party claims for the reasons stated in our brief. If I could just briefly address, I wasn't addressed before, didn't have time. If your honors don't have any questions about our tort claim, I think we can rest on our brief on that. We didn't have an opportunity to discuss before I sat down. But I will say, this is not duplicative. It is not a duplicative claim. New York law, as we set forth in our brief, permits additional tort claims for a variety of reasons, including when the public has a significant interest in the defendant's services and the failure may result in catastrophic consequences. That's the Trustees of Columbia case, 192 AD 2nd, 151. The BDG case, which is a Southern District case that we cited that summarizes New York law, also includes such as what happened here when the perpetrators of the negligence failed to comply with New York statutes and regulations. It's clear that that's what happened here. In fact, it was admitted by the crane operator that he didn't comply with the New York Department of Building regulations. I see I'm out of time, and thank your honors for a long day. Good job.